All right, welcome everyone. Today we're going to be talking about the SPQ and the AVID. And last week we talked about the TDS. That whole class was kind of TDS, but you see, we're going through all of the letters of the alphabet, right, and putting them together into different, mixing them up. So the TDS is the transfer disclosure statement. That's the required in California most of the time when you're selling a mobile home or a single family home or a condo or a townhome up to 4 units, 1 to 4 units. And there are some exceptions which we talked about, and it requires that the seller disclose the defects that the seller knows about, but it's focused, that disclosure, on a very specific form. In addition to the statutorily required transfer disclosure statement, and I'm muting everybody. If you wish to speak, unmute yourself and speak. So in addition to filling out the required form, the seller is also required to disclose all known material defects in the property. Now we're going to start with the SPQ, which is not required by law. There's a law that requires the transfer disclosure statement, but there's no law that actually requires the seller property questionnaire. Not a law. It's in most of the contracts that are used in the state of California. If you're using the California Association of Realtors standard form purchase agreement, it's going to make reference to the seller property questionnaire and make that a required document in the transaction. If you're in the San Mateo County, let's say, there's a specific form that's called PRDS that is used in that county some places. It's not a CAR form, and they have their own questionnaire. It's called the Seller Supplemental Checklist. So, they're pretty much the same. So if we're not required to use the form, then why do we use the form? And the answer is we use the form because it gives a guide for the seller and asks the seller specific questions. Some sellers and even real estate agents don't want to talk about things that are wrong with the property, right? They just as soon not mention it. Why do you need to say that? Why do you have to put down that it smells bad? Why do you have to do that? And the answer is because there are a lot of lawyers, and that if you fail to disclose a material fact, the result could be you're going to end up meeting lawyers. Right, you'll be talking to lawyers, you'll be writing lawyers, sending lawyers money, right? Because it can be considered a form of fraud, right? So the agent, in addition, is supposed to do their own visual inspection, which we're going to probably spend more time on because I know that's the sexy one. I don't know if that's the right word, but anyhow. So we pasted in links to the folder that I've collected stuff in. And this is part of the MDGC. Those of you that are on right now only have access to this particular folder unless you're part of the Michael.devlin group, by the way, with eXp Realty. And by the way, for those of you that are part of the group, I was notified yesterday that our team reached a mega icon status again. It's done. What that means is that we did more than $40 million in volume in the last rolling 12. Actually, it wasn't even that far back. We have until October actually to hit 40 million in volume, and we've already done that. So, that doesn't mean, take it easy, right? But I'm just saying. The seller property questionnaire, let's take a look at it. If you have questions, you can unmute yourself and speak. If you are, you want to type them in, I'll probably get to them at some point. So here's what the seller property questionnaire looks like. Now, one of the things that I've included in, and I'm going to go to these links, it's in a document, is that from the real estate agent's point of view, sometimes the biggest challenge involving the transfer disclosure statement and the seller property questionnaire is how exactly do you get the seller to fill it out, right? I mean, what exactly do you do? Now, there is a notice that we give to the seller and get them to sign that talks about their disclosure duties. But I have a suggestion. If you're representing a seller, right, because this is a seller property questionnaire, if you're representing a seller, you might want to actually first have read the disclosure advisory yourself. I believe I have a copy of that in the folder. If not, find one on Zip Forms, and maybe go through and explain it to them. Because what I've noticed that real estate agents tend to do is we use electronic signatures and forms that are sent by email, and we get people to sign them, but they don't really read them. I hate to surprise. In fact, most real estate agents haven't read the forms. It's easily 90% of the questions I get asked by real estate agents about the forms is like stated right in the form. But, you know, it's easier to text me than it is to go through the form and see if you can find it yourself. So if the agents aren't really reading the form, how would we expect the seller to actually read through all that stuff we give them? So the seller tends to just sign everything and then, you know, move on. So the point of you communicating about that is that you can explain to them why we're doing it and why it's necessary, and maybe help them with it, right? Now, as I mentioned when I talked about the transfer disclosure law, if I'm a buyer, if I'm representing a buyer, we are representing a buyer, and our buyer has removed all their contingencies, and now something has gone wrong with the transaction, and our buyer wants to get out and they want to get their money back, but they don't have any contingencies. When I get that issue, which has actually been kind of common lately, the first thing I do is I look at the transfer disclosure statement and I look at the seller property questionnaire, and what I'm looking for is a mistake. I'm looking for something, a question that was not answered, or a question that was obviously answered incorrectly. Now, once I've identified a mistake, what we do is we send a 2-day notice to perform to the seller, telling them you got to fix the form because this and this and this are not true. And the contract and the civil code for the TDS both say that if the seller amends these forms, amends the transfer disclosure statement, amends the seller property questionnaire, it triggers a 3-day right of rescission by the buyer. So the buyer can, so when you give them the 2-day notice to perform, one of two things are going to happen. One, the seller is going to amend it, which gives you the ability to back out because there's a right of rescission, or they ignore it. Recently, we had one where the listing agent just said, I'm not going to even answer your emails. Well, what that does is that if after 2 days they have not complied with the notice to perform, the buyer can now cancel the contract and get their money back. Do you understand? If you and the seller screw this up, you've given the buyer potentially a get out of escrow free card. All right. And I'll tell you that the last thing we want as listing agents and sellers is for the transaction to not close. That's why this is important, right? And I'll show you some of the software, but you might actually have to answer questions. There's a disclosure information advisory, remember, which I mentioned, a disclosure information advisory. I don't do this. Do I want to do this? No, I don't want to do this. Anyhow, a disclosure information advisory reviewing the seller ought to read. You might want to talk about it. There are limitations. You know, the following are representations made by the seller are not the representations of the agents. Right. So what we're saying is if the seller is lying on this form, it's not our fault. Disclosure is not a warranty of any kind by the seller or any agents and is not a substitute for any inspections or warranties the principals may wish to obtain. So the buyer has an obligation to also use due diligence and to inspect the property, assuming they have an inspection contingency. And if they do, they ought to have one. Unless otherwise stated and specified in writing, broker and real estate licensee or other persons working with or through broker has not verified information provided by the seller. By the way, I'm going to invite some of the lawyers to speak again, but I was listening to one recently, and they were going through what are the most common reasons that real estate agents get sued. And one of the things that is high on that list is when the real estate agent gives information to the buyer without really explaining where it came from, and that the agent has not verified. And there's a court case that was like the big one. I have snippets from it, but I'm not going to torture you with them. And in this court case, somebody had bought a lot with the idea that they were going to subdivide the lot. This was in San Jose. And they were told by the seller and the listing agent that it was more than an acre. Right? Their agent, the buyer's agent, said, yeah, this is what they say. And then they buy the property and escrow closes. And they find out it is actually less than an acre. And by the way, in San Jose, at that time, they had a rule that said if you wanted to do what the buyer wanted to do, you needed to have at least an acre. Otherwise, they didn't want to talk to you. They sued. Now, the agent that represented them said, I just passed on the information the listing agent gave me. Right? But they never said, I have not verified this information. Right? They didn't come out and make it clear that all I'm doing is passing on stuff that the seller and listing agent have given me, and it may or may not be true. Right? So that's a comment when we get to AVIDs and things like that. Because all right, so it's good to use the transaction coordinator. My team has a very good transaction coordinator. There's pluses and minuses, as you might guess, to everything. One of the pluses is you're more likely to get all of the paperwork filled out. And by the way, at EXP, if you don't have it all filled out, they're not going to let you get paid a commission. This is true at most real estate companies. So that's a plus, right? The other thing is that it's more, the errors and omissions insurance companies have discovered that transactions without transaction coordinators generate a higher percentage of lawsuits than the ones with transaction coordinators. And there's a movement among the errors and omissions insurance companies to require transaction coordinators if you want insurance. I'm just saying, right? So you're more likely to get paid on time, less likely to get sued. Those sound like two strong arguments, right? But when the lawyers are talking to people that clients that want to sue agents, one of the big comments they hear is, after we were in contract, we never heard from our agent again. All we ever talked to, the only person that ever was the transaction coordinator. We never heard from the agent again. So even if you should have a transaction coordinator. If you're on my team, you have to have a transaction coordinator, because if you don't use our transaction coordinator, I'm the one who ends up becoming a transaction coordinator, and I ain't going to do it. Right, so you ought to use it, but that doesn't mean you shouldn't be talking to your clients on a regular basis just to see how it's going, right? Because if you don't communicate and they think something's wrong, they're more likely to sue. All right, so we did that. That was more than you wanted to know. Note to seller: the purpose is to tell the buyer of known material facts affecting the value or desirability based on actual knowledge. Something that you do not consider may be perceived differently by the buyer. So you want to include a lot of things. Think about what you would want to know if you were buying today. They give advice, right? The buyer inspection advisory does that. There's also a note to the buyer that says this is to give you information on known material facts. And so Brandon, go ahead, that's fine. Brandon, I was wondering, I have more than one Brandon. Brandon's with Chicago Title, and yes, you should talk to him if you would like to get support. All right. So the buyer, it says that this is just known material of facts. The sellers are not a substitute for your own investigation, personal judgments, or common sense. We'll talk about specifics a little bit. Seller, this is basically explaining how to fill out the form. Now notice number 5 in documents. Reports, inspections, disclosures, warranties, maintenance recommendations, estimate studies, surveys, or other documents, whether prepared in the past or present, including any previous transaction, and whether or not the seller acted upon the item pertaining to, goes on and on and on. Do you have any of these? Now, you'll notice that paragraph 5 is essentially asking the seller, do you have anything when you bought the property 5 years ago, 10 years ago? Did you get inspections and reports and things like that? Did you? And if the answer is yes, you're supposed to mark yes and provide a copy to the buyer. Even though, well, what about 10 years ago? It doesn't have a time limit on it. Now, I'll tell you, one of the things that makes the lawyers, spidey senses, start to tingle is that when somebody says, well, we bought it 2 years ago, but we don't have any of the documents. Oh, really? And by the way, real estate agents and brokers are required to keep them for at least 3 years. So they're probably someplace, but why would they not want to show us? And especially if this is a flip, right? So in the flip, they had property inspection, termite inspection, they had inspections, and the place had lots of issues. That's why it was a flip. And so they bought it, and then maybe didn't fix it, right? Maybe they didn't get rid of the mold in the wall, but they replaced the wall, they painted, they put something on top of the floor. You understand, they made it look okay, but they didn't necessarily do the work that was suggested in those original inspections. So that's why they're saying, termite, we don't have any of that stuff, oh, really? That's a form of fraud, right? So that would be one of the things you need to think about when you're talking to your seller is how long ago was it that they bought this property? And, if it was recent, was it a fix and flip? And you get the idea. Statutorily, contractually required or related. So some of these that are in this group here also appear on the exempt seller disclosure, because that's the one where even if you don't have to do a TDS, and even if you don't have to do the whole SPQ because you didn't live there, somebody died and you're the executor, you still have to answer these questions. Has anyone died in the last 3 years, yes or no, on the property? Now, sometimes people say, I don't care, right? But, and by the way, some people really care. So if they ask, if they being the buyer, let's say somebody died 5 years ago on the property, but the buyer asks, has anyone ever died on the property? You can't lie, right? This doesn't say if it's been more than 3 years, you can say no, because the 3 years is part of the California Civil Code, and it says that if somebody has died within the last 3 years, that has to be disclosed to a buyer, assuming it's a transaction where a transfer disclosure statement is required. Order from a government health official. Contaminated by methamphetamine. Yeah, we actually have a methamphetamine disclosure. I'm not making that up. Release of an illegal controlled substance on or beneath the property. Is it in an industrial zone? Is it in a another manufacturing or commercial zone, an industrial use zone. Now, a natural hazard disclosure company like Disclosure Source would give you a report that would also answer these questions. But what we're asking here, does the seller know if it is or it isn't? Right? Does the seller know? And if the seller's read the NHD report, they might, say, well, now I know. But anyhow, you get the idea. Is it within 1 mile of where there might be military ordnance, like bullets and unexploded bombs and things like that? Is it in a condominium? Are there insurance claims in the last 5 years? And by the way, you would, if there are insurance claims, we would typically get what's called a CLUE report, a CLUE, which is a report that shows whether or not the property can be insured. Because if you've used your homeowner's insurance too often, then they don't want to insure you anymore. Matters affecting title. Do you know? Plumbing fixtures that are non-compliant, that means low flow water fixtures. Low flow water fixtures, right? Do you know? Right now, there's a law that says they're supposed to be compliant, but they don't come and check unless you live in certain counties. Santa Cruz County, they're going to come and look at your toilet and your shower and all that to see if you've got water conserving plumbing fixtures. And if you don't, you've got to put them in. And if you don't, you're not going to be able to sell. Material facts or defects affecting the property not otherwise disclosed. This is like a free throw. Is that correct? Anyhow, it's anything else you can think of. All right. And by the way, when sellers say, well, do I have to disclose that a couple of doors down, they fix cars, at night and smoke weed on the street? Do I have to disclose that to the buyer? Now, the general rule is if the seller asks you, the answer is yes, right? They say, well, the next door neighbor turns the hose. I actually had a seller say this, that the next door neighbor deliberately sprayed her with water when they were washing their car, and did she have to disclose this? And I said, yes. If you ask me, the answer is yes, because you have to disclose anything that might affect the value or desirability of the property. Repairs and alterations. How am I doing? All right. Have you done any repairs or alterations? One of the things that looks weird, I'm just saying, and this would come up on an AVID, and I would ask if I were at the house, is you have a room and one wall has been painted. One wall. Why would they only paint one wall? And usually, often the answer is because there is something wrong. There was a leak, there was mold, there was something wrong. And so fresh paint actually is a red flag that something might be wrong with the property. Have you done any of that? Ongoing or recurring maintenance, drain or sewer clean out. Our clients buy a property, there's trees in the front, the sewer line starts to have problems, and because the roots are clogging it up, and the buyer calls a local, Roto-Rooter type company, and they said, what's the address? The address said, oh, well, you want us to come out and drill it again, and they said again. They said, oh yeah, we have to go there like every few months, right, to clear the line. Lawyers, right, because obviously they knew about it. I mean, but they didn't mention it, right? And any part of the property painted last 12 months, whether it was built before 1978. Now, the reason for that is that if it was built before 1978, with a few small exceptions, there's a lead-based paint disclosure. Now, the lead-based paint disclosure doesn't require that you have tests done to see if there's lead paint. By the way, a lot of the paint before 1978 had lead in it. So I'm just saying, but you're not required to test it. You're just, and most of the time the sellers don't know whether or not that was lead paint back that long ago, but it triggers another form. It triggers another form. Structural systems and appliances, defects in any of the following. That seems pretty, straightforward. The leasing of any of the following: solar systems, water softener, water purifier, alarm system, propane tanks. That's the big list. So just because there's solar panels on the roof doesn't mean that the owner of the house owns the solar panels. Doesn't necessarily mean they own the water softener system. It doesn't mean they own a water purification system or an alarm system or propane tanks. Many of these can be leased. And if the buyer is buying thinking, I'm getting all of that, there's a paragraph in the residential purchase contract that says the seller is supposed to give copies of all those leases. So right now we want to know, is there anything leased? And you'll notice that if you check yes to anything, you're supposed to explain what it means, and there's an overflow addendum if your explanations are going on and on and on. Go ahead. Disaster relief or insurance civil settlement. Have you received disaster reliefs? Did it burn down a little while ago? Has it been destroyed by earthquakes or floods in the past or damage? You're supposed to, mention that. Because if the ability of the buyer to obtain the necessary insurance not only is a good thing for the buyer, but also is usually a condition of the buyer getting a loan. Water-related, mold issues, any leaks. When you run your sprinklers, does it sort of pond in the middle? Is there a fungus among us? Right? Is there mildew? Any of those problems? Yes, mention it. Pets. Do you got any? Do you know that if any have lived there? And I've had sellers say, "Oh no, my pet has a really strong bladder." I actually had a seller say this, and she had a document from a vet attesting to her dog's strong bladder, trying to argue that the dog couldn't obviously have done anything wrong. You close the windows in that house on a hot day, you can tell. We'll get to that. So that's something to think about. Livestock, wildlife, insects, pests, wasps, rodents, things like that. You get the idea. Most of this is straightforward. Do you know if you're the seller of any boundary issues? Are you fighting with your neighbor about whether the fence is in the right place? Are you arguing? Landscaping, pool and spa, if you got one, right? You've obviously probably got landscaping, but that's not always. But do you have any defects? Do you have a pool? Do you have a spa? Now, by the way, if you've got a pool, I would recommend a pool inspection. And if the seller doesn't get one, the buyer ought to get one. But condominiums, and I've got problems right now with transactions because of condominium issues. Right, in one of them, in one of the condominiums, they need to replace the siding. It's going to cost $3 million. They don't have $3 million. And all of that sort of stuff, and so now you can't get loans on the property because the HOA. We had another one in Alameda County where the HOA was putting in things into escrow about wanting money to be withheld because of deferred maintenance. That freaks out the lenders. So Ellen wants to know if we can talk about AVID about the odor in the AVID. The answer is yes. We'll get to that question when we'll get to the AVID soon, very soon. Title ownership, legal claims. Most of this is just reading it. It was noticed that somebody had noted, I think it was Juan, that said you could get a PPA loan, also known as a PACE loan. These are loans for buying solar property. If there is one, we need to know about it, because those loans have what are called the super priority, which means they have to be paid off before escrow closes. They can't be paid off from the escrow proceeds, which means someone's going to have to come up with the money. You get neighborhood neighbors. What about the dog? I hear dogs barking at night. Do I have to put that down? Do I have to mark that down? And says yes. Right? Somebody down the street, has a band and they practice at night. You got to put that down. Can you hear the freeway, trains, light rail? Can you hear stuff? Right? You need to put it down. Are you near the high voltage transmission lines? When you walk outside, can you just feel the electricity in the air? Right? You got to put that down. Right. So you ought to, as an agent, carefully read what the different things are that they're asking the seller about, because somebody has to, and you might need to help the seller, By the way, one of the transactions we had, so the buyer moves in and the loud music, the party house, right, which is like 2 doors down, starts up. Right, like 10 o'clock, and like 3 nights a week, the party house is having a party. And so they eventually call the police, right, to complain about the party. And the police say, so what address are you coming from? And they gave the address of their new home. And the police said, oh yeah, gotcha. You're calling again, huh? Calling again. Oh, yeah. Lawyers soon got involved, because obviously the seller knew they'd called and reported on the party house, but they did not say anything. Right? Any things going on with the government restrictions, protected habitats. We have a transaction where one of the things the buyer wants to know, is it in a historic district, right, which you can see referred to. My thing doesn't really, anyhow, you can see it referred to. And you'd want to know, because sometimes when people get a notice that their house is going to be designated as a historic property, you might think, aren't they excited? The answer is no, not necessarily, because it limits what you can do. You can't just renovate the house. It limits you. Right, so any of that kind of stuff is included. Anybody smoking on the property, any remodeling due to cannabis cultivation or growth, right? That's what all that extra power in the attic was for. Right? Any other material facts, any past or known material facts or other significant items affecting the value or desirability. Can you get the idea? They're really trying hard to get the seller to say everything. Right? So this is a quick guide, which the California Association of Realtors has many of, about the seller property questionnaire. Right? So any questions about that? Let me see. These songs don't own systems of their age. One sells solar panels, by the way, if any of you want to buy one. Just thought I would. So let's get to the fun one. The fun one?
Michael, this is Teresa.
Yeah.
So a previous mentor had said, hey, try to stay as disinvolved with that as possible. But it seems like we have a role in kind of making sure our sellers kind of understand that form and that they're putting everything down. What's your thought on that?
The real estate agent has a responsibility to help the seller with these forms. I have some screenshots from a presentation that an attorney did on that subject. So should we just give them the form and say, go for it? If they make a mistake, the buyer's going to be able to cancel the contract, right? Just to start with.
Well, and possibly hurt our sellers. I mean, by litigating,
Right. you're not supposed to be stupid, right? So for example, this one recently, this property, the problem we were having was a homeowner association document. And the seller on the TDS and SPQ marked no to whether or not they were in a homeowners association. Right, now you're saying that's a, you know, and so what that did is that's what gave us a easy exit from the transaction if we wanted to. One of the software programs that you can use to help sellers do this, and maybe before we get to that, I believe I put in my folder a document. Let me where is it? All right. So these are some of the software tools. Oops. And one of them, I didn't want to launch that one, by the way, but one of them, which is called Glide, you can watch the seller completing the forms. You can see what they're choosing. Now, and sometimes you stop them and say, you know, question number 14, did you really mean no? Oh, yeah. And I use Zoom or Meet or been there with them, right? I have a very portable laptop. I sometimes there with them when they fill out the form. Now, what these programs do, and there's 3 of them that I listed here. I'm going to put a space between those. Are 3 programs that are designed to help sellers and buyers fill out disclosures. And if you send this from zip forms, they get a big page and there's parts that are highlighted for them to answer. And they can go through on the TDS and the SPQ and type stuff in. If they use Breeze, Glide, or Seller's Shield, then they're basically on their screen asked one question at a time. And they answer it and can add, you know, oh, well, this is what happened. And it puts it in, it's a lot more customer friendly. Okay. And so Glide actually shows you when while they're doing it. And so and I've called people and said, you know, well, let's go back. So in theory, real estate agents shouldn't have anything to do with this. You send it to the seller and they can fill it out themselves. In theory, that might be true. But in reality, most sellers need help in filling out this form. Most sellers need help. They have questions. What does this mean? Right. And as I recall, the lawyer that I was listening to recently talked about how the agent had a duty to help the seller, right? Because you have a fiduciary duty to the seller to represent their best interests. And although, anyhow, that's enough. I would be prepared to help them fill out the form. All right. So this is the AVID. I think I got guidance on visual inspections. There's a couple of them. This is the agent visual inspection disclosure. So I'm gonna, here we have, could you mute? Somebody is making espresso. Or not, I don't know. Sounded like, I still hear sounds in the background. Maybe, anyhow. It says, let me try it again. All right. So here's the agent visual inspection disclosure. Now, you might guess that an agent visual inspection disclosure is a visual inspection disclosure, isn't that right? So that would mean that this form only applies to things you can see. Is that right? If it's a visual inspection disclosure, does it just mean visual inspection? So if I'm, open up a window in the bedroom and I can smell the mushroom plant that's not very far, that's olfactory, not visual. So I guess I wouldn't have to mention that it smells bad in that neighborhood. And if I heard dogs barking, shots being fired in the not too distance, I don't have to put that down either, because it's not visual. Well, you still have to put it all down. So it goes beyond visual. That is correct. You have more senses than just visual, and anything that so you would have to include all those things. All right. So this is inspection disclosure concerns the property in. You fill it out. Now, what they have added recently is the box. This is a duplex, triplex, or fourplex. And notice it says additional forms are required for other units. If you have a fourplex, there would be 4 AVIDs. 1 for each unit. They're not only, first of all, you talk about cracks in the wall of the kitchen. Well, which kitchen are you talking about? Where, inspection performed by. So this form, a lot of times agents have difficulty with the form, filling it out. Right, this is required by Civil Code Section 2079. The actual form is not required, but the fact that you have to go through the process is required. And most large brokers, EXP included, require the form rather than you just writing down nothing noted. So 4 units, 4 AVIDs, 1 for each unit, 3, you get the idea. Inspection performed by broker firm name. So if I were filling this out, I would put in EXP Realty, right? Not my name. Now you might be thinking, well, I'm a broker. Can't I put my name there? No, I'm a broker too. We don't put our name there. We put the broker's name there, right? And even though I am a broker at EXP, I am not the broker at EXP. So that would be EXP Realty. It requires that they collect a reasonably competent and diligent visual inspection. Reasonably competent. Now, there's 2 parts to this. One part is disclosing material defects. The other part is being competent, right? These are 2 different parts. So, for example, if the seller does the TDS and the SPQ, and you get a property inspection, termite inspection, a roof inspection, right? You get all those inspections, and everything conceivable that would need to be disclosed was disclosed to the buyer, and you screwed up your AVID. You did a terrible job. You missed obvious things. Still, no harm, no foul. Most likely, because if it's obvious, if it's open, in other words, if it's already been disclosed by the seller, the property inspector, the termite inspector, if it's already been disclosed to the buyer and you don't disclose it a 2nd or 3rd or 4th time, that's not a big deal, right? Because the buyer can't say, well, my agent didn't tell me about it. Yeah, it was the seller did, and the prelim, it was, you've gotten 4 or 5 notices. So when does this become an issue is, let's say you're being sued. You're being sued. And what they're arguing is that you were negligent in the transaction. And you're like, no, I was on it. And then they say, well, let's take a look at your AVID. Let's take a look at it. Let's go through it to just see how reasonably competent and diligent were you in completing the AVID. So you understand, even if it's not if we get all the inspections and reports, the chances that you're going to see something that they don't see, not a high percent. Though there's some things they don't like. For example, the property inspector isn't going to make notes about noise in the neighborhood or the smell sometimes, but usually not, right? You understand there's some things you could disclose as an agent that the property inspector wouldn't disclose, but most of the time they're going to disclose everything.
Michael?
Yeah.
Hi, it's Neil from Southern California. I said it last week, but what I have been doing is I actually print the form out and I videotape it. Then I go back to my office, which is my home office, to fill it out. And I look at the videotape if I missed anything, and it's worked very well on my inspections. So that would be a tip.
Yes, that's a good tip. So one of the functional parts of this, right now, if you represent the seller, you ought to be doing this before you put it on the market. Right? You ought to be doing it before you put it on the market. The contract says, I'm sure you all know this, the contract says that the seller has 7 days and the listing agent to turn over all the required documents. I know you all know this. And then it says the buyer has 5 days to back out of the transaction if they don't like what they see. If this is done prior to the buyer making an offer, those time periods don't apply anymore, right? Because you've already given it to them. They already could have read it. So if you're the listing agent, you're going to want to make this part of the disclosure package that we really want the buyer to read in advance of writing an offer. Because what we don't want to do is renegotiate the price in the middle of the escrow. And if you don't have a termite in the property and you don't have any of that, you're going to be renegotiating the price in the middle of escrow once the buyer has gotten the reports and found all this stuff. If you're the buyer's agent, that's when this becomes a little trickier. One of my peeps, so she's showing property that's at least an hour and a half away from where she lives. And she meets her clients up there and they saw a house after house, they saw a whole bunch of houses. And then the buyer picked out one and afterwards, and they wrote up an offer and they're in escrow. The buyer's agent, transaction coordinator, reaches out to the buyer's agent and says, where's your AVID? Where's your AVID? And the buyer agent, this by the way is somewhat typical, had not prepared one. Now, and by the way, because they looked at so many houses, this one was sort of a blur to her. And she doesn't remember if there's weathered floor in the kitchen. She doesn't remember any of that stuff. So what do? Read the property inspection, look at their pictures and copy stuff. It doesn't work very well. Read the listing agent's AVID and paraphrase. That's not a good idea either. Or drive an hour and a half back to the property to do the AVID. So when you're showing a house to a buyer, it wouldn't hurt for you to take notes, either a video note, a picture, or an audio recording, so that if your client chooses to make an offer on that property, you already have an AVID ready to go. And some of those apps that I talked about, and which I'm going to probably still mention before we're done, some of those apps, because they're phone apps, you can record directly into an AVID form on your phone the things that you are diligently and competently visually inspecting. Right? Fill it out. How about this when you show the house? It'd be good practice, wouldn't it? Right? Then you don't have to go back. How about this, though? Well, we're going to have a property inspector. By the way, whether or not the transaction closes is dependent upon the listing agent's AVID, but not the buyer's agent's AVID. If the listing agent does not provide an AVID, the buyer can back out of the contract. Even if the seller is exempt, the listing agent is not exempt. But the buyer's agent, it says you're supposed to do it, but it also says that you can't, this is in both the civil code and the purchase agreement, that the buyer can't back out just because their own agent wouldn't do it. You can see the logic in that. All right. So how about this then? We're having inspections done. Why don't I just go there then? And I follow the inspector around and I make notes. This is not a good idea. First of all, you are only required to visually inspect the property. You're not supposed to be testing the dishwasher, looking at whether or not the hot water, is hot. In other words, the property inspector is testing components, which you're not supposed to test. And if the property inspector says, oh, wow, this, the electrical panel seems to be out of date and not serviceable, you're going to write that down? Are you an electrician? Are you sure you wrote it down word for word the way it was supposed to be? And if it's going to be in the property inspection, why are you writing it down? You're not supposed to do that. You understand? You're not supposed to do that. So you're supposed to walk through the property and look around and look for certain red flags, right? Like cracks, like discolorations, smells, uneven floors, and there's a list. Notice it says, California law does not require the agent to inspect areas that are not reasonably and normally accessible. You don't have to go into the attic. You don't have to go crawl under the house. Areas off-site of the property. Well, if it's a condominium, do I have to go look at the pool and the common areas? The answer is no. Those are off-site. Public records or permits. So this is a big thing. One of the reasons that real estate agents get sued is they take on I'm going to get all the permits and find out what's going on with the property for my buyer. This is dangerous, right? Because if you, as an agent, pull permits, you become responsible to some degree for the outcome, like you didn't get them all, or they were the wrong ones, or you didn't understand them. So what I always recommend is that you want and by the way, I've seen listing agents now that have copies of permits and things like that in the package. But if I'm representing a buyer, I want the buyer to contact the city and ask them all the questions they have about what can we do with the property, are there anything going on with the property? I want the city to answer the question. Right, you don't want to get involved in that. Right now, does that mean I can't? I send people a link. You go to this website. See here, the Planning Commission for the city. See the phone number? And by the way, most of them have permit searches. Agent, was there a comment? I heard noise. Agent inspection limitations. We don't go on the roof. We don't go into the attic. We're not going to move furniture around. Look behind the paintings. We're not going to crawl in the chimneys. We're not going to open locked doors. Missing screens need to be disclosed. Sure. I actually had a buyer say when the screen was missing, he said, the only reason I bought this house is because I thought there were screens on all the windows. Really? The only reason? Exterior, we're not going to look underneath, we're not going to climb up a hill, we're not going to look behind plants, right? We're not going to operate systems to see if they work. We're not going to measure stuff, right? I've been involved in transactions where the buyer and the seller were fighting over the square footage of the lot. There were differences of opinion as to the square footage of the lot. The buyer actually went out with a tape measure and measured it themselves. First, that assumes they know the proper location of the boundaries, which may or may not be the fence line. Environmental hazards, we're not going to, test for mold and asbestos, lead. Now, by the way, I've sold a house more than one. So I listed it, I sold it, I went on a listing appointment years later, and the owner said, have you ever sold any houses in the neighborhood? And I said, I sold this one to you. So if I knew because of a previous transaction that there was asbestos. See, that's different, right? I have to disclose that. You don't need to test the water faucet or the sink when you do a visual inspection. The answer is no, you don't need to do that. But that's what a property inspector does. Property inspector flushes the toilet and runs the water and runs the dishwasher and does all that stuff. Analysis, anyhow, for what, so this, again, there's a paragraph that basically says we're not trying to take the place of a property inspection. It's not a replacement for the TDS or the SPQ. Right? California law specifies that a buyer has a duty to exercise reasonable care to protect him or herself. So you should do your hire inspectors yourself. Now, this is where it actually starts. If the property is a duplex, triplex, fourplex, you put in a 1. What if it's a 5-plex? Would you put in 5? That was a trick question. And the answer is no, because if it's more than 4 units, you don't have to do this form. That's why. It's only required 1 to 4 units. If the buyer decides to cancel the contract, can the escrow company come back and charge the buyer for escrow fees after they cancel? Is there anything a buyer? So Brandon, do you want to answer that question as to what Chicago Title's reaction would be to a cancellation? I know the answer, but let's see if Brandon is still there. Well, maybe not. Well, you missed your chance. So the answer is no. They generally, title companies, although the purchase agreement and law that relates to this isn't very much, does contain the possibility that cancellation could result in a fee, typically for the preliminary title report or things like that. I've been in real estate a long time, and I've never known of an escrow or title company to charge a fee when somebody's canceled the contract. Never. All right. So 1 to 4 units, inspection performed by, this is again the name of the broker, EXP Realty, right, or whatever. Date, time, and weather conditions. Who cares? Well, if it's cloudy, rainy versus sunny, it might affect what you could see, right? Anyhow, you're supposed to put it down. Inspection, daytime, other persons present. You got witnesses. Anyhow, if there was somebody else present, you can write it down. I don't have a great explanation as to why that's there. Entry, including common areas. So sometimes we disclose if you're walking to the property and there's uneven steps and things like that, the concrete has, it's uneven, and that's going into the front door. I'll take a picture of it, and I would note that. Common areas is obviously like an HOA or that sort of thing. So we're looking at the entry. This means really specifically once you've opened the door and you've gotten inside. And if there's nothing to note, you put nothing noted. Living room, dining room, kitchen, other room. So just some comments about the kinds of things that you would note. So let's say you see cracks in the wall. And one of the things I'm going to do when I'm going to have a lawyer come and talk about what are called the red flags. If you Google searched, you would find them. But red flags would be, is there paint? Has the wall been painted? Are there cracks? Is there a sign of weathering? Right? Is there, what else would be a good one? Cracks, weathering. Are the floors uneven? Is there evidence of something growing on the wall? Something obvious, visual, right? And you would make a note. You want to use the fewest number of adjectives. So don't say normal wear and tear is visible on the entry floor. Normal? What's that mean? Isn't normal a setting on a clothes dryer? You know, I don't know, right? You know, so do you really, what's normal? Normal to who? Normal to you? Normal to the buyer? Right? So you don't say normal. Oh, there are hairline cracks on the wall in the kitchen. Hairline? Is that a technical term? Right? You're measuring the cracks, you know? Maybe it'd be better to just say there's cracks on the wall. By the way, take a picture. One of the links I gave you is an instructional video on how you can take pictures of all the things that you see. And sometimes that's a lot easier than, you know, explaining it. All stairs, excluding common rooms, bedrooms, if you have more than 3, which is quite possible, we go down other. If you have more than 6, I don't know, right? We make an addendum to it. Baths, if you've got more, you can add an addendum for additional rooms or fixtures, right? You could do that, right? So, but normally, you know, there are a lot of 4-3s, but anyhow, that's you have some room to maneuver in adding them. You could add an addendum if there's a lot more. Garage parking, there's almost always cracks in the garage floor because it's a slab and settling and things like that. There's oftentimes grease stains and you just notice that. Exterior building and yard, the front, sides, and back. And if there's danger, I saw this court thing about dangerous vegetation. And I was thinking, gee, are they talking about this huge, you know, Venus flytrap that grabs people as they walk by? But it was trip hazards, right? Where there was all these vines and things that were around the walkway. The other observed or known conditions not specified above. While you're doing the AVID, you can hear dogs barking. I'd write it down. You hear a train go by. I'd write it down. Right? You get the idea. Right. Let's say you happen to know that there's a meth house, a party house on that street because you're an area specialist and you've sold properties in that neighborhood and you happen to know that those things exist in the neighborhood. That's where you'd write it down. All of these programs, by the way, have the ability to create additional, it's called what's it called? A text overflow addendum, right? So you can just keep writing and writing and writing. I've had sellers, I mean, we came up with pages of stuff. So this would be a good quiz question. When I'm feeling particularly sadistic and I have time, I'm warning you, I'm going to do this on some session, is I'm going to give everybody a test, an exam. Does that sound like fun? Right. I promise not to send your score to the Department of Real Estate, right? For a small fee. But notice there's a box that says signature of associate, box up here, but then down here. So let's say I'm the buyer's agent. There's the box. And then down here, it says the firm representing the buyer. And then it says associate. Why are there 2? Because it looks like that box in the middle is asking for a signature from one of the people that signed at the bottom. Well, not every agent carries out their own AVID. So it is legally possible, your broker may not like it, it is legally possible to have a team member, associate, usually from the same brokerage, who likes doing AVIDs and is good at them. You could delegate to them and they could go do the AVID, in which case they would be signing in the middle box. But you, down here at the bottom, are still the agent in the transaction. Does that happen very often? No, no. So usually what this means is you're signing twice. You're signing in the middle in the box, and then you're signing at the bottom, depending on whether or not you're the buyer or the seller's agent. All right, now, this is some stuff about the AVID. This is a pretty good slide deck from CAR. They explain why, you know, we have the law, the TDS, they go through it. They talk about a summary of what's going on. They give you examples, non-visual sounds. There's some examples of what you could or not, you know, what you might want to say, more examples. There's you should use it, right? You should use it. All right, was that enough? Are you visually, you know, inspected? All right. So next week, I'm trying to decide if I should do a couple of more disclosure forms or an update on the residential purchase agreement. It's been a little while since I did that, and there's been some changes. Where is the slide deck? Everybody should have received, because we've been pasting it in, a copy of a folder. And what's a mellow roof? That's a roof on top of a house that is really laid back, and it's super, no, that's not right. So it's a mellow roost, R-O-O-S. And no, the roost does not refer to rooster or kangaroo or anything like that. A mellow roost is a community facilities district where there's a bond placed on property for the purpose of paying for something. I see a lot of them for libraries and stuff like that. Here, let me see, a mellow. And so, and that's a link to the folder. So the thing about a mellow roost, and it's named after two politicians, a guy named John Mello and a guy named Roos, from a long time ago, is that if you were to buy a property that has a mellow roost bond on it, it can't be paid off in escrow. So that means the buyer would be buying the property and assuming that future indebtedness. And sometimes they go on forever, right? Because as long as the library is there, right? And a lot of times they're not that much. I see a bunch of them with $50 and things like that, but I saw one with $8,000, right? You know, it was a, you know, it all depends. So the reason they do that is that rather than trying to get a property tax increase for a large geographic area, it may make more sense to get the people who live within a very small area that are going to be benefited from whatever the improvement is going to be, that local improvement, to pay for it, and that's usually done through the bonds. You oftentimes see them on new home subdivisions as well. Anything else? Any other questions? All right, coolio. Thank you, everybody. Next week, we'll be doing something else. Bye.
Thank you, Michael.
Thank you.
You're welcome. Bye, y'all.